Welcome back everybody to the Law of Tort. In this video we are continuing talking about the breach of duty and the standard of care in the context of negligence, and we're going to focus on this idea of the application of the standard of care, being able to apply the standard of care to factual circumstances. Now we're going to cover a couple of cases and then we'll cover some instances by which it is validated in the way in which we can essentially apply the standard of care. We'll talk about how the standard of care is established in a number of cases as well. So, when we think about the standard of care and when we think about the application of the standard of care, there has to be a number of considerations that we have to keep in mind. Don't forget, the application of the standard of care is essentially taking all the things that we have looked at in previous videos, talking about things to do with the reasonable person, maybe making adjustments on the basis of the Bolton test, or even making adjustments lower on the basis of the consideration of defendants being children. And then actually taking all these informations, taking all these principles, and then applying them to the factual circumstances of a particular case. Now, the considerations that we have to think about was the extent to which the magnitude of risk existing in the performance of a particular action. What was the magnitude of risk? Was it an unjustifiably risky action? Or was it something that was particularly not conducive to a significant amount of risk? Did the defendant take any precautions to avoid any kind of risk? And so when we ask these questions, these are the two questions that we generally consider. And when we think about it, the magnitude of risk essentially asks the question of how risky, how dangerous was the action in question in terms of potentially giving rise to the events that take place that causes some kind of damage. And then given the fact that there was a certain amount of risk, what precautions could have been taken and what precautions were taken by the defendant in order to avoid or minimize the risk that was had. Take the first case example that we're looking at today, the case of Bolton and Stone. The facts of this case involve the defendant who had been playing cricket in a club. The ball would ultimately fly over the fence of the club, where it would subsequently hit a pedestrian who was walking down the street and just walking past the cricket club where the ball flew. For anybody who has ever held a cricket ball, they're not like a tennis ball. They are very, very solid. If you get hit in the face or in the head with a with a cricket ball, that's going to really hurt, depending on the velocity. It would really hurt a lot more than any other ball that I can think of, really, except for maybe a billiards ball. The question here was that of an application of a reasonable person standard. So essentially we're asking the question in this case about whether or not there was a breach of the duty of care and whether or not the defendant, who was just simply playing cricket in the club, had gone below a standard of care in being able to minimize the amount of risk to the potential claimant. What was the magnitude of risk? And what actions were taken by way of precaution? Were these precautions reasonable? Were they reasonably expected of a reasonable person? Okay. The courts held that the likelihood of something like this happening was relatively low. So in terms of asking the question as to the magnitude of risk, they concluded that there wasn't a particularly high magnitude of risk. There are a few reasons for this. Firstly, it was only on rare occasions that the ball would actually ever fly over the fence, and then even in those cases, the chances of that actually leading to an individual being hit would also be very, very low. And then on top of that, the idea of an individual being hit and then seriously injured as the result of all of these factors all suggested that there was a relatively low magnitude of risk. It was also noted that there was an option for the club to install a larger fence, but the cost of doing so was seen to be invasive. So while it was seen to be the case that this would have been a precaution that could have prevented the injury from happening, this was seen to be something of an unreasonably high level of standard for a precaution for something of this nature, given the fact that the magnitude of risk was so low and the cost and the invasive nature of installing a larger fence was so high that it led to a situation where it was seen to be a bit higher than a basic standard. So given all of these factors and taking them into consideration, the playing cricket in the manner that was stated was seen to be within the reasonable expectation of the standard of care, and so the claimant had no negligence claim. There was no breach of duty, given the fact that this was generally within the reasonably expected standard of care. A few years later, we get the case of Overseas Tankship United Kingdom and the Miller Steamship Corporation of 1966. This is sometimes referred to in textbooks and in the case law as the Wagon Mound number 2 case. We will get to the first Wagon Mound case when we talk about remoteness in a future lesson. But this case involved negligent action in the releasing of oil into Sydney Harbour. Essentially, what had happened was there was a boat which had released oil, a tank ship had released oil into Sydney Harbour, which had then spread, and as you know, or should know generally speaking, the oil floats on top of the water. Sparks from a nearby welding operation led to the oil that igniting and causing a substantial fire, which would damage other items that existed in the harbour. Now, the Privy Council asked the question as to the extent and the magnitude of risk in these circumstances. So, were the people who had allowed quite negligently the oil to spill, were they liable for the damage that was caused by the fire? Well, what was the magnitude of risk for the oil catching fire? Given that the fact that it was floating on top of the water, and given the fact that the welding operation was a little bit further away than the oil tanker, it was seen to be the case that there was a relatively low magnitude of risk in terms of the risk of the oil actually catching fire. No one really believed that would be something that would happen. But however, it was still nevertheless present. There was still a risk that existed. Balancing this idea against the fact that there was no reason for the oil to be released in the first place, nor was there any cost in keeping the oil from spilling, it meant therefore that there was a failure on the part of the defendant to meet the standard of care of a reasonable person. The reason why this is the case is because the the Privy Council at least, balances out the relatively minor risk with the even lower standard by which it would have been easy to fulfill in the ensuring that there was no oil being released into the harbour in the first place. So everything was relatively low in terms of risks and in terms of actions that could have been used and utilised to prevent said risk. And so even though the oil catching fire was a relatively minor risk, there wasn't much magnitude of risk, it was still nevertheless one that could have been prevented by very menial and very cost-effective and very, very easy decisions on the part of the defendants. And so as a result, there was a failure on the part of the defendant to meet this standard of care.